closed session. Please be seated.
All right, we are back on the record. Just because not everybody was here this morning, just a reminder that each side is permitted 15 minutes of argument. My understanding is that the department and the Child's Council will be splitting time. I also understand that counsel for the mother is appearing via Zoom based on a motion she filed this morning, which we've allowed, but that you will not be able to see the timer. So I will advise you when you are running out of time. I want to remind everybody that this case is impounded, so please do not use any of the parties' names. With that said, this is the Department of Children and Families and Another versus Mother and Another, docket number 24P1110. Attorney Clay.
Thank you. Good afternoon, Your Honors, and may it please the Court. Thank you again for allowing me to appear virtually today. My name is Kyla Clay, and I represent the mother. When a parent has cognitive impairments or limitations that affect their ability to organize and follow through with services on their own, DCF has an obligation to make reasonable efforts to make reunification with their child possible by providing services that accommodate that parent's specific needs. Unfortunately, that didn't happen here. Since the start of this case, DCF knew mother's cognitive impairments required additional services and support to help her parent her child. And DCF knew that mother needed hands-on support to access these services. But despite its statutory obligation to do so, DCF failed to provide mother with the reasonable efforts necessary to help her reunify with her child, and then blamed her for the agency's own failures. And the juvenile court agreed with DCF.
Can I ask you a question? At record A14 through 16, there's a letter from counsel to the department regarding ADA accommodations, but I didn't see anything in the docket or in the transcripts that brought this issue before the juvenile court judge. And under Daisy, aren't you required to do so, and therefore isn't the question waived?
No, Your Honor, this issue is not waived for two reasons. First, as you mentioned, contrary to DCF's claims that mother never had, discussed the adequacy of her services, mother did actually raise this issue through DCF, through her lawyer with DCF, well before trial. But even if she had
with the judge?
So even if she had never directly raised that issue with DCF or the judge, it wouldn't matter because of the second reason, which is that this court held in adoption of Chad that a claim of inadequate services is not waived when the parent's cognitive deficiencies and resulting needs for services were a theme that ran through the life of the case. And here, mother's cognitive limitations and resulting difficulties accessing services were a recurring issue throughout the case from the very beginning. Indeed, DCF voiced early concern about mother's capacity to utilize services given their concerns for her intellectual disability. And then DCF repeatedly informed the court that it was working on reconnecting mother to DDS services and repeatedly dropped the ball. So the court had numerous opportunities through the DCF court reports and the DCF and the court investigators report to see that mother needed certain services, which DCF was very aware of. Yet DCF was not taking the steps necessary to make sure mother was getting those services. So the fact that mother didn't raise the claim of inadequate services through a traditional reasonable efforts argument at trial does not mean that this issue has been waived.
But don't we have to read Chad in the backdrop of Rashida and Rashida 2 and the progeny, which talk about the parent's obligation to raise it? Chad's an older case.
Right. So there are some more recent cases that we can look at as well as, for example, adoption of Elena, where this court talked about why a claim of inadequate services normally needs to be raised in advance, which is to provide both the judge and DCF the opportunity to make accommodations while the case is still pending. As noted in Adoption of West, a 2020 case, this is so that way DCF has noticed that its efforts may be inadequate and has the time necessary to remedy that issue. But here, when the parents' cognitive deficiencies and their corresponding service needs were repeatedly a center of the case, that notice has essentially been baked in. DCF already knew exactly what mother needed. They knew what services she needed and what would work for her, and they dropped the ball. And the judge knew as well, because the judge was receiving the DCF court reports, which made it very clear that mother needed to re-enroll in DDS services and was supposed to get help from her social worker, but her social worker failed to ensure that she completed the application appropriately. They then never provided any further updates on DDS services. They also made it clear that mother needed, at one point they say, quote, mother needed DV 101, unquote. And yet, throughout the entire case, they repeatedly say how much mother needs domestic violence services, but they never discuss in the DCF court reports what they're doing to refer mother to services or assist her in getting those services. So the court knew, and DCF knew, that mother needed services that she wasn't getting.
Right,
so
can
I don't.
Ask you, I knew Yelena sounded familiar. It turns out I wrote it. And what I say in there, on behalf of the court, is that while the department has an obligation to make reasonable efforts, the parent also has an obligation to substantially fulfill her parental responsibilities, including seeking and using appropriate services. So can you address that second component?
Yes. So the most important thing to note here is that mother needed, and DCF knew that mother needed, quote, significant amount of support, unquote, with accessing and maintaining services. And DCF also knew that mother would be unsuccessful at engaging in services and treatment without someone directly helping her. So the most important resource that mother needed was help re-enrolling in the Department of Developmental Services, which would have provided her with the hands-on support she needed to both enroll in services and keep herself organized and maintain the ability to actually follow through with services. DCF knew from day one that was the most essential thing that needed to happen in order for her to participate successfully in this case. And mother did do the steps of filling out the DDS application to re-enroll in services. And mother repeatedly told DCF she wanted to re-enroll in DDS services. But she was missing a signature on the DDS application, and DCF knew this. Her social worker made no attempts, however, to help her get that missing signature. Even though her social worker spoke to her on the phone every week, all the social worker did was tell mom to go to the DDS office and figure it out on her own. And knowing that mother needed this support with accessing and maintaining services, it wasn't enough to simply go send her off with an address to DDS and expect her to be able to re-enroll in those services on her own. She needed DCF to help her with enrolling in DDS services, and then she would have received the help that she needed to more successfully engage in the services and referrals that DCF was trying to send her. So that's one crucial part there that I think that DCF failed to ensure mother had support with. And they knew additionally that mother was struggling to, quote, participate in the warm handoff, unquote, approach to the referrals early into the case. They knew that mother was not able to keep up with everything that DCF was suggesting that they do, and that she was overwhelmed with all of these referrals to services. And essentially that meant all of those services that they were referring to her would be rendered meaningless, because again, mother didn't have the DDS services that she needed in order to participate and enroll in services.
Can I ask you about a different issue that you raised, because I want to make sure I understand it. You are not necessarily saying that any of the judges, I think 234 factual findings are clearly erroneous, but that somehow the conclusions of law under 210(3)(c) are erroneous because of the findings the judge made? I just want to make sure I understand that claim.
Yeah, so I'm essentially saying that, in addition to the fact that, there was a lack of reasonable efforts, there's also this abject failure to provide these services under 210 Section 3C. And the trial court decided to apply these factors and essentially say that, yes, DCF did provide the services that were intended to correct the circumstances of mother's parental unfitness. Yet, when we look at when we look at the case, we can see that DCF did not provide those services. DCF did not make sure that mother had DDS services. DCF never provided her with mental health referrals. They never provided domestic violence referrals or services. And the court, in holding that the department did meet this obligation and applying the 3C factors, this raises to a level of legal error beyond just an abuse of discretion, because these 3C factors are in place to ensure that courts are distinguishing whether a parent's unfitness is merely temporary or long-term. And so I think it rises beyond the simple abuse of discretion review for a lack of reasonable efforts. And if mother had received these efforts, then we don't know whether mother would have remained unfit. So the court essentially holds that mother would be unfit for an indefinite period of time, even though mother never received the appropriate services necessary to help her correct her alleged parenting deficiencies. And so, for example, she never received any referrals to domestic violence services. She never received any referrals to mental health services. And again, the most important thing, receiving DDS services, even that DCF failed to ensure that she had. And so when we're looking at the judge's findings here that mother would be indefinitely unfit, that is also an error because, again, DCF didn't provide the services that were necessary for this court to determine that unfitness was going to continue into the indefinite future. Indeed, DCF themselves believed that mother had the potential to be a good parent and demonstrated an ability to improve when she was provided the right guidance. And we do see that she did engage in services when she was provided the support necessary. For example, mother does engage with her parenting aides. She also does engage with the family nurturing program. She takes some parenting classes. She finds housing with the help of the family nurturing program. Mother needed more hands-on support, but there's nothing in the record that would say that mother would have completely refused that support if she was provided it. In fact, mother repeatedly said she wanted to re-engage in DDS services, and DCF was the agency that failed her here.
You have 3 minutes. You have 3 minutes.
Thank you, Your Honor. So DCF has an obligation to make sure that reasonable efforts to assist parents in reunifying their children are provided, and that those efforts must be tailored to that individual parent's specific needs. And in this case, DCF knew exactly what mother needed. They had
interrupt you for a moment.
Yes.
What exactly did DCF fail to do? What specific, other than physically walking to the DDS office location to have her sign, but what exactly are you alleging that DCF failed to do for reasonable accommodations? Yeah.
So, the first obviously is the DDS services. They understood how incredibly crucial DDS services were for mothers to participate and engage in any of the other services. And really all mother would need was that support with signing and finishing the application. It was a very simple step that DCF could have taken to connect her to the most crucial services possible, and yet they didn't take that step. And then the other most important things are DCF focuses a lot of time, and so does the court, on the mother's relationship with father and how they believe that this is a controlling relationship. Yet at no point does DCF try to help mother get services to domestic violence resources or help. At no point do they even try to have a serious conversation with mother about why they think that this behavior could be considered domestic violence, which was essential because they knew that mother had cognitive limitations, and women with cognitive limitations can take a little longer to recognize intimate violence like this. And so the department completely failed on that end, and yet they repeatedly said that if they wanted mother to be able to participate in addressing her mental health, for example, they thought that they would also need to address the domestic violence concerns as well. They made no effort to do that.
1 minute, counsel.
Thank you, Your Honor. And then finally, they made no effort to refer her to mental health services, even though they repeatedly say that that was a serious concern for them as well. So when a parent has cognitive impairments that make it difficult for them to connect and follow through with services, like here, DCF cannot meet its statutory obligation to provide reasonable efforts by merely flooding the parent with meaningless referrals to services, especially when they know that that parent's cognitive impairments make it impossible for them to simply take off and run with those referrals. If reasonable efforts is to hold any meaning, it requires more than this. Therefore, mother respectfully requests that this court vacate the lower court's judgment and remand the matter with instructions to hold another trial after DCF provides mother with appropriate and accessible reunification services. Thank you.
Counsel. Please just put yourself on mute while we have the rest of the argument. For the department, Attorney Fasoli, good afternoon.
Good afternoon, Your Honors. Carol Fasoli on behalf of the Department of Children and Families. The mother's overwhelming parental unfitness was proven clearly and convincingly at trial, and as found by the trial court, the department properly made reasonable efforts towards reunification with mother. I would agree with Your Honors that in the first instance, this argument of reasonable efforts was waived. It was never brought up at trial. In fact, I believe what is now technically on the record, but is part of the reply brief that my sister provided, was a letter at the beginning of the case requesting, services accommodated, and it was the department's, also she included the department's response to that letter, which showed the different services that we were providing, and if they had any problems with that, they could have filed a further appeal, given our ADA policy.
Are these letters in the trial court's records?
They are not. That was attached to the reply brief, because it wasn't before the trial court, because, as Your Honors pointed out, this issue was never raised at the trial court. And even if it wasn't waived.
They were never filed as exhibits or anything like that?
Correct. Even if, hypothetically, the issue of reasonable efforts was not waived. The fact is, the department, in this case, went well overboard in providing services. Now, keep in mind, this child was born, was not removed till 7 months after the child was born. There were concerns at the hospital, maybe even warranting a removal, but the department chose to try to work with this family. Maternal grandmother was involved. The parents had no medical, no supplies for the child or anything, but they thought, all right, let's try to work with this family, which is exactly what they did. So the first, they provide services, they provide family stabilization services. Again, recognizing, no one is disputing that mother had some cognitive limitations. And they were also questioning father's cognitive limitations at the time. Again, working with a family stabilization unit that could, or service, that could work with this family. The problem was the parents, mother particularly, they refused these services. In fact, in the first 7 months, there were 2 separate family stabilization services provided. The first one, the department didn't feel was sufficient enough because mother needed a primary care in order to have a neuropsychological exam done. So they provided a second one, which was, I believe it's youth villages. It was a higher step up that could work. These services worked with the family. They come in 3 days a week. They try to connect you to service providers. Again, knowing mother's cognitive limitations, trying to have a special family stabilization that could have hooked her up with individual therapy, mental health treatment, and I mean the starting point was getting that neuropsych done. Again, in addition, they did referrals to early intervention, 4 referrals to early intervention, even set up the appointments. Mother no-showed with the child. Again, there was also the social worker testified, she walked mother to the family nurturing center to set up the input. The family nurturing center could have connected her with family stabilization as well as domestic violence, which is what the social worker testified at trial. Again, the intake was done, and then the services were terminated because mother didn't follow through. The fact, after the removal, these same services were offered. In fact, because the removal involved one of the family stabilization social worker, they changed that family stabilization person to work with the family. Right after removal, they tried to reach the parents, tried to work with the parents. Mother repeatedly said she didn't want extra people in the house. She didn't, again, understanding that mom had those cognitive limitations, the department was trying to work with this mother and trying to, they provided weekly visits, which, again, the social worker testified about 50% were missed of these visits.
What about the issue of domestic violence? It seems that the trial judge did spend some time talking about sort of father's presence and overarching control, I think, over mom's decisions. What did the department do vis-a-vis domestic violence and mom as a victim?
So the social worker was asked that at trial, and she referred to this family nurturing service. Again, it's not specifically focused on domestic violence.
We see so many cases where DV is an action plan and there are very specific programs and resources. Doesn't seem like that was provided here.
But in context of mother refusing and not participating in all services that had been recommended to her, a separate DV, which there is no likelihood, mother wouldn't even go through with the family nurturing, which isn't even as, and furthermore, mother herself denied any, or she didn't acknowledge any DV. There was no physical violence in the record between mother and father. And I would agree with Your Honor that there was controlling.
Like there was sort of at least an inference that some of mother's poor decision-making was as a result of influence by father, like she wouldn't sign the action plan because of him. Doesn't that send up a red flag that there is some power imbalance between mom and dad?
Oh, and I don't think anyone disputed that, that there was concern, they shared a cell phone. Mother even said to the social worker, if I do some of my services and he doesn't do any, can I still co-parent with him? Because that was her plan, was to co-parent with him. No one is disputing that there wasn't domestic violence issues. The problem is, what would go attend a domestic violence separate group? Mother had demonstrated throughout this course of this case that she wouldn't even participate in the simplest of services like a family nurturing center, wouldn't even work with a family stabilization social worker who was coming to the house to connect mother with all these various services. So there's nothing to say that if you added another task on her action plan of go to a separate domestic violence group would have made a difference in this case.
They're in the unenviable position, and it's difficult in the one hand because you don't want to be criticized for stacking services that aren't attainable, so small steps. But then when the decision seems to really highlight the issue of control and domestic violence, and there isn't a specific domestic violence that I saw.
No, and it is true that, but again, that's the social work, again, working with someone who they all recognize has some limitations. If they can't even accept someone who works for the department, a third party, if they won't work and connect you with, a party, how could you expect them to be able to go separately to a domestic violence group? And the thing is, the mother, I believe, there was a parenting course she took 5 out of the 14, but again, stopped going. The DDS application, the social worker and the family stabilization service worker worked with mother on the application. They filled the application out. Again, DDS services is a volunteer service. The department can't force the mother to participate in DDS services. So at every visit, the social worker testified at every visit, she contacted the DDS previous worker that the mother had. So they were waiting for it. They tried to contact mother. Again, mother and father shared a cell phone, and throughout the course of the case, it was very difficult sometimes to get a hold of the parents. So other than the worker walking the mother down to the DDS office, which again, heroic measures are not expected, yes, the mother's pattern was to not participate in services.
Can you, only because of your time, can you speak to the 210-3C argument that mother has raised?
The department would dispute that this is, I guess the premise is the department didn't provide the proper services. The department contends it did. It tried to work with this mother, by these family stabilization services, by providing early intervention, offering daycare for the mother, to help her. And she said, I can watch my own child. Again, all these services were provided, and that's why the trial judge properly considered them in measuring the mother's parental deficiencies that were never cured throughout this case. So if there's no further questions, I would rest on my brief.
I don't see any. Thank you very much. And now we will hear from Child Counsel.
Good afternoon, members of the panel. Ana Maria Joy on behalf of the appellee child. My client is asking this court to affirm the lower court's termination of mother's parental rights because the judge properly evaluated all of the evidence and found by clear and convincing evidence that mother was unfit at the time of trial, that her unfitness would likely continue into the indefinite future, and that it was in the child's best interest. As Chief Justice Blake correctly noted, the trial court made 234 separate findings of fact, all of which were very specific and detailed in their analysis. I'm going to briefly address two issues. One, mother's lack of parental fitness at the time of trial was her own doing and not because of her low IQ. And two, DCF's efforts to help mother. As to the first issue, there's no question that mother did suffer from low IQ. But there are three very specific examples that this court can rely on where mother showed an ability to assess a situation, go through a thought process analysis, and show problem-solving capacity despite her low IQ. Example number one, when father was incarcerated around March 2022, mother discussed leaving father with her social worker. And she wanted to pursue a DNA test to potentially show that the child was the biological child of someone else, not father, even though he is the one that signed the birth certificate. Mother reported that she was in a different relationship and that she was looking to move into a different apartment. Example number two, again in March of 2022, mother realized that she would not be feeling safe with a visit with the child and the father because they were sharing visits, and she canceled the visit. And she specifically said that she told the social worker she did not feel safe having visits with the father due to threats she received from the father and his sister. That's finding of fact 182. So this shows that mother realizes she's not safe with this person and trying to get some distance from him. And example number three, which I think is the most telling, is in October of 2022, the parents were supposed to, they did attend a joint visit, but mother was incredibly late because she had to bike from Jamaica Plain to the DCF office in the rain because the father would not transport her in the scooter. So this is finding of facts 53 and 196. So the mother did not call the social worker to say, I'm overwhelmed by traffic, I don't know how to get there, what do I do? She showed initiative and she showed tenacity, and good for her. She thought, I'm going to do what I have to do to visit my child. She showed up late and soaking wet, but she was there. This isn't someone that said, I don't know how to get there, social worker, please help me, I'm not going to go. This is someone who showed in this instant, this is a problem, this is how I'm going to solve it, I'm going to do what's in the best interest of my child. And again, good for her for doing that. Unfortunately, she was not able to be consistent. And briefly, I'll just touch on DCF services for mother. Before DCF removed the child, on my brief in pages 13 to 16, I list all of the services that DCF provided. After DCF removed the services, after DCF removed the child, on pages 17 to 19, I again list all of the services that mother was provided. And again, mother was repeatedly offered services and rebuffed them at every turn. There's only so much DCF can do other than literally moving a DCF social worker into mother's home or physically forcing her to accept these services and follow through.
Thank you. We'll have to leave it there. These are always very difficult cases, and I appreciate the arguments of all counsel. The matter is under advisement.
Thank you.
That also concludes today's sitting. I'd like to thank our court staff, in particular our clerk's office, for quickly pivoting to a hybrid hearing this afternoon. Of course, our court officers and our law clerks. We are now in recess. Thank you all.